A letter arrives one beautiful sunny morning in your mail. It's from a former client, one you haven't heard from in the last year. You did a really complex project for that client about a year ago. You were pretty excited about that project. It's front and center in your portfolio. You open the letter. It says, "Dear design professional, this letter is to advise you that you have failed to meet the standard of care in the design of my project. We anticipate repair costs to fix your mistakes to be about $1 million. We await receipt of your check." You are stunned. What does this mean? I failed to meet the professional standard of care. How do I know what that is? The professional standard of care is the minimum degree of care which a design professional must meet in order to avoid legal liability. If you meet or exceed the standard of care, you will have no liability for damages in a court of law or an arbitration proceeding. But if you fail to meet that standard of care, if your conduct falls below that standard of care, then you will be held legally liable for the damages which your client has incurred. How do I know what the standard of care is? I know I exercised care when I did this design. That is not where we look for it. The standard of care is typically found in your written contract, but on occasion the contract may be silent on it. The acceptable standard of care to put in a written contract is that degree of skill and care ordinarily expected from members of your profession performing the same or similar services under the same or similar circumstances in the same or similar locale as you. The standard of care that I just discussed with you is the acceptable standard of care that you should try to include in your contracts. However, oftentimes owners like to have higher standards of care. And oftentimes they find a basis for that standard of care in your promotional literature or in your pitch for the project. They say, "But you told me that you perform in accordance with the highest standards of architecture." Be careful, because if you include in your contract a higher standard of care than reasonable skill and care, you face two major issues. You may have agreed to perform in accordance with a standard of perfection. No errors in your plans, no omissions in your plans, not even minor ones. Unattainable? Probably. And when you agree to a higher standard of care, whether the word be higher or highest, you create insurability issues. If you are sued for breach of a higher standard of care than the law would otherwise impose on you, reasonable skill and care, then your insurer may deny coverage for your claim. So be very careful that the standard of care that is included in your written contract is reasonable skill and care. Now, how do I know what reasonable skill and care is as a design professional? Well, it's actually established by your peers who are performing those similar services. It's not necessarily what you did or what your neighbor might do. It's what your peer group does. A plaintiff will typically have an expert who will say what the standard of care is and will opine that the standard of care was breached by you. In defense of the suit, a design professional will typically have an expert who will opine as to what he believes or she believes the standard of care is and that there was in fact no breach. What happens next? Now we have two experts that disagree. Well, that happens quite often in the world of litigation. And then it becomes an issue for a judge or a jury, or in the case of an arbitration, an arbitrator to decide. And that's a scary thought. You really don't want to be there. So please make sure that the standard of care that you include in your contract is reasonable skill and care and nothing higher. The standard of care is not necessarily the best way to design something. Oftentimes there are multiple ways to design, and there may be several ways to comply with the standard of care. Please make sure that you consult all applicable codes and make sure that you comply with those codes. A failure to comply with applicable codes will be deemed a breach of the standard of care. The plaintiff's expert's way of doing things is not necessarily the standard of care, nor is your expert's way of doing things. The court will make the determination as to what is in fact the standard of care, or in the case of a jury trial, a jury will make that determination. So, two takeaways from today's discussion. Make sure that your contract contains the proper standard of care, reasonable skill and care, not anything higher. And make sure that you exercise reasonable skill and care in the performance of your design services as well as your construction administration services. If you have any doubts as to what to do to comply with the standard of care, consult your peers, consult the applicable codes, because any failure to comply with applicable codes is likely to be deemed a breach of the standard of care. If you follow these 2 takeaways, it will go a long way toward properly managing risks on your projects.